page 59. As the record now reflects, at the time of the opening of Crossfire Hurricane, the FBI did not possess any intelligence showing that anyone associated with the Trump campaign was in contact with Russian intelligence officers at any point during the campaign. Moreover, the now more complete record of facts relevant to the opening of Crossfire Hurricane is illuminating. Indeed, at the time of Crossfire Hurricane was opened, the FBI, albeit not the Crossfire Hurricane investigators, was in possession of some of the Steele reports. However, even if the Crossfire Hurricane investigators were in possession of the Steele reports earlier, they would not have been aware of the fact that the Russians were cognizant of Steele's election-related reporting. The SSCI Russia report notes that sensitive reporting from June 2017 indicated that a person affiliated to Russian oligarch 1 was possibly aware of Steele's election investigation as of early July 2016. Indeed, in early June 2017, USIC report indicated that 2 persons affiliated with Russian intelligence services were aware of Steele's election investigation in early July 2016. Put more pointedly, Russian intelligence knew of Steele's election investigation for the Clinton campaign by no later than early July 2016. Thus, as discussed in Section 4D1A3, Steele's sources may have been compromised by the Russians at a time prior to the creation of Steele's reports and throughout the FBI's Crossfire Hurricane investigation. C. Interview of the Australian diplomats. On August 2, 2016, 2 days after opening Crossfire Hurricane, Strzok and Supervisory Special Agent 1 met in London with the Australian diplomats to assess and clarify exactly what had been said by Papadopoulos in May and provided to the U.S. government in July. In preparation for the interview, Strzok and Supervisory Special Agent 1 sought the assistance of the FBI's legal attaché in London, UK ALAT1. UK ALAT1's primary FBI responsibilities in London include, among other things, collaboration and information sharing with British Intelligence Service 1. In UK ALAT1's interview with the office, he pointed out the inherent importance of sharing information with the British Intelligence Service that related to potential Russian intelligence activity in the United Kingdom. Thus, the UK ALAT1 briefed the British Intelligence Service about, page 60, Papadopoulos' allegations involving the possible Russian influence in the Trump campaign. Given the nature of the allegations and the speed of which Strzok and Supervisory Special Agent 1 needed his assistance, UK ALAT1 assumed that the FBI's interview of the Australian diplomats was exceptionally critical. UK ALAT1 also believed that the Crossfire Hurricane investigators likely were in possession of compelling facts beyond what UK ALAT1 understood from the substance of Papadopoulos' claim in paragraph 5. Nevertheless, UK ALAT1's independent impression of the prediction of the predication for the investigation was echoed by Supervisory Special Agent 1 in a link exchanged with UK ALAT1, during which the predication was referred to as thin. UK ALAT1 also recalled Strzok making a comment in the taxi on their way to the Australia High Commission to the effect that there's nothing to this, but we have to run it to the ground. These exchanges with Special Agent 1 and Strzok resonated with UK ALAT1 because in sharing the Papadopoulos information with his British Intelligence Service 1 counterparts at the time, they expressed real skepticism about the motivations and the reliability of Papadopoulos. UK ALAT1 told the office that British Intelligence Service 1 did not assess the information about the Russians and Trump attributed to Papadopoulos to be particularly valuable intelligence. Indeed, he told the FBI's Inspection Division investigators that the British could not believe the Papadopoulos bar conversation was all there was, and they were convinced the FBI must have had more information that it was holding back. As it relates to predication for opening Crossfire Hurricane as a full investigation, after Strzok and Supervisory Special Agent 1 had traveled to London and interviewed the Australian diplomats on August 2, 2016, the following link exchange between UK ALAT1 and Supervisory Special Agent 1 on August 11, 2016 is instructive. UK ALAT1, dude, we are telling them, British Intelligence Service 1, everything we know, or is there more to this? Supervisory Special Agent 1, that's all we have. Supervisory Special Agent 1, not holding anything back. UK LAT1, damn, that's thin. Supervisory Special Agent 1, I know. Supervisory Special Agent 1, it sucks. Page 61. UK LAT-1 went on to tell the Inspection Division that in discussing the matter with a senior British intelligence service, one official, the official was openly skeptical, said the FBI's plan for an operation made no sense, and asked UK LAT-1 why the FBI did not just go to Papadopoulos and ask him what they wanted to know, a sentiment that UK LAT-1 told investigators that he shared. Later in the fall of 2016, UK LAT-1 was at FBI headquarters with some of his British intelligence service one counterparts. While there, members of the Crossfire Hurricane team played the audio-visual recording of CHS-1's August 20, 2006 meeting with Carter Page. UK LAT-1 said the effect on the British Intelligence Service 1 personnel was not positive because of the lack of any evidence coming out of the conversation. UK LAT-1 told the OIG that after watching the video, one of his British colleagues said, for explicitive sake, man, you went through a lot of trouble to get him to say nothing. At a later point in time, after the Mueller Special Counsel team was in place, UK LAT-1 said that the Brits finally had enough. And in response to a request for some assistance, a British intelligence service, one person, basically said there was no explicitive way in hell they were going to do it. From his vantage point, UK LAT-1 saw the FBI executive management was pushing the matter so hard that there was no stopping the train, and he told the OIG that, it was this thing was coming, so my job was to grease the skids for it, and that's what I did. Had the Crossfire Hurricane investigators attempted to critically assess the information from Papadopoulos through FBI holdings and the standard request to other government agencies for information about Trump and Russia intelligence activities involving Trump, they would have learned. Jonathan Moffat served as the chief of the FBI's counterintelligence analysis section through 2016. Moffat was a career FBI intelligence analyst who began working as a full-time FBI counter-espionage analyst in 2004. And prior to being selected for the section chief position on January 2016, he had been chief of the Russian analysis unit for approximately 4 years. Moffat advised investigators that he had heard nothing about Trump and Russia until events began to be reported in July 2016. Page 62. Also, the FBI intelligence analyst, who had perhaps the most in-depth knowledge of particular sensitive Russian intelligence information in FBI holdings during the relevant time period, disclosed that she never saw anything regarding any Trump election campaign conspiracy with the Russians, nor did she see anything in FBI holdings regarding Carter Page, Michael Flynn, George Papadopoulos, or Paul Manafort engaged in any type of conspiracy with the Russians regarding the election. Similarly, DNI James Clapper testified before Congress on the subject of Trump and Russia, and he answered no when asked if he was aware of any such evidence. The former DNI confirmed that this fact when he was interviewed by the office and advised that he knew of no direct evidence that would meet the legal standard of a conspiracy or collusion on Trump's part. Admiral Mike Rogers served as the director of NSA during the relevant time period. When asked about any awareness he had of any evidence of collusion as asserted in the Steele reports, he stated that he did not recall any intelligence that supported the collusion assertions and that reporting, nor did he have any discussions during the summer of 2016 with his counterparts in the intelligence community about collusion between the Russians and any Republicans. Victoria Nuland served as Undersecretary for Political Affairs at the Department of State during the relevant time frame. A career employee of the Department of State and one of its most experienced Russian observers, she told our investigators that she never saw any U.S. government proof of the allegations contained in the Steele report regarding Trump and Russian officials, and further stated, to her recollection, no information regarding a well-coordinated conspiracy between Trump and the Russians had ever come across her desk, with one exception. Nuland advised that she had received a 2-page, page 63, summary of the Steele allegations from Jonathan Weiner, who in 2016 was serving as Secretary of State Kerry's special envoy to Libya. Weiner told Nuland that Weiner had prepared the summary from the review of the Steele reporting while he was at Steele's country house in the United Kingdom. Nuland thought Weiner had passed the summary to her sometime in July 2016. I'm going to read 2 footnotes from page 62. The intelligence analyst did, however, find some information related to Manafort that was not connected to the election or the presidential campaign. OSC Interview Report of Headquarters Analysis 3 on August 14, 2019. That was the reference. The other item is, Nuland also pointed out, however, that if reporting is about a U.S. person, it is heavily redacted and compartmented before it would come to her attention, and that it was possible that she would not have seen all the information. She said that the masking rules are followed when it comes to providing intelligence reporting, and that she would have had no national security reason to see reporting on the sex-related allegations concerning an American businessman. In her view, for the State Department, it was not intelligence if it pertained to U.S. persons. Back to 63. CIA Director John Brennan and Deputy Director David Cohen were interviewed by the office and were asked about their knowledge of any actual evidence of members of the Trump campaign conspiring or colluding with Russian officials. When Brennan was provided with an overview of the origins of the Attorney General's review, after Special Counsel Mueller finding a lack of evidence of collusion between the Trump campaign and Russian authorities, Brennan offered that they found no conspiracy. In fact, Special Counsel Mueller's report explicitly states that ultimately his investigation did not establish that the Trump campaign coordinated or conspired with the Russian government in its election interference activities. Relatedly, however, shortly after Special Counsel Mueller delivered his report to the Attorney General and the Attorney General had issued a short summary of the report's findings, Brennan appeared on MSNBC's Morning Joe program where he stated that he suspected there was more than there actually was with regard to collusion between the Trump campaign and Russia in the 2016 election, thus suggesting that he had no actual knowledge of such information. Moreover, Deputy Director Cohen advised that he had no recollection of knowing anything Trump was doing with Putin, as opposed to what Putin and the Russians were doing to interfere with the election. Cohen stated that if there was such, page 64, knowledge, it would have been included in a formal referral to the FBI. In addition, if the CIA had become aware of any U.S. person being involved in a criminal conspiracy, it would have sent the information to the FBI in a formal referral. He advised that he was not aware of any such referrals in this matter. I'm going to read one footnote from page 63, 1 or 2. Prior to the release of the Mueller report, and specifically in an August 16, 2018 opinion piece, the former director had characterized the claims of then-President Trump that there was no collusion with Russia as, in a word, hogwash. The second footnote from the Mueller report. Although the investigation established that the Russian government perceived it would benefit from a Trump presidency and worked to secure that outcome, and the campaign expected it would benefit electorally from information stolen and released through Russian efforts, the investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. The Mueller report says the evidence was not sufficient to charge that any member of the Trump campaign conspired with the representatives of the Russian government to interfere in the 2016 election. Back to page 64. In any event, within days after opening Crossfire Hurricane, the FBI learned from interviewing the Australian diplomats that there were reasons to be unsure about what to make of the information from Papadopoulos. Not only had Supervisory Special Agent 1 and Stroke told UK LAT1 that what they had was thin, but one of the Australian diplomats had told Stroke and Supervisory Special Agent 1 in their interview that the paragraph 5 information was written in an intentionally vague way because of what Papadopoulos did and did not say. Nonetheless, shortly thereafter, the FBI opened a full investigation of Papadopoulos, Carter Page, General Michael Flynn, and Paul Manafort. All four were U.S. persons associated with the Trump campaign, and all of them, other than Papadopoulos, had either ties to Russia or a history of travel to Russia. In July 2016, in addition to receiving the first several Steele reports, the FBI received a separate stream of information regarding Trump from a former FBI CHS, specifically an FBI supervisor from a New England field office, New England Supervisory Special Agent 1, was contacted unexpectedly by the former CHS, with whom the supervisor had worked many years earlier when assigned to a different field office on matters related to Russian organized crime. New England Supervisory Special Agent 1 agreed to meet his former CHS on July 21, 2016. At that meeting, the CHS told New England Supervisory Special Agent 1 that he or she had been contacted by a colleague who owns an investigative firm and who was looking into Trump's various business contacts and ventures in Russia. The former CHS did not identify the investigative firm that day, except to say that the firm had been hired by the DNC and another unnamed individual. The former CHS then provided New England Supervisory Special Agent 1 with a list of approximately 45 individuals and entities who reportedly had surfaced in the firm's investigation of Trump's ties to Russia. Page 65. The list was compromised mostly of Russian individuals and entities and immediately raised red flags for the New England Supervisory Special Agent 1, who believed it was necessary to get the information into the right hands as soon as possible. Following the July 21, 2016 meeting, New England Supervisory Special Agent 1 emailed a counterintelligence colleague about the meetings and forwarded the list of names he had received. Within a few days, New England Supervisory Special Agent 1's email and the investigative firm's list of names made its way to FBI headquarters and to the Crossfire Hurricane investigators. The former CHS reached out to New England Supervisory Special Agent 1 again on August 23, 2013, telling him that he or she had received a large volume of material that the investigative firm had compiled, and the former CHS passed on more information from that effort. New England Supervisory Special Agent 1, in turn, passed the information directly to an agent on the Crossfire Hurricane team, Special Agent 2. Then 1 month later, on September 23, 2016, the former CHS reached out yet again, prompting New England Supervisory Special Agent 1 to email the Crossfire Hurricane investigators again to report that the CHS had more information on Trump's reported ties to Russia. Months later, on January 11, 2017, after the dossier had been made public, New England Supervisory Special Agent 1 asked Supervisory Special Agent 1 if anything was to be gleaned from the information he provided in July. It was at that time that Supervisory Special Agent 1 let New England Supervisory Special Agent 1 know that his team had received the same information through a separate reporting stream from a different source, in context being Steele. Supervisory Special Agent 1 further advised that the second source was working with the same investigative firm that had given the information to the former CHS. Sometime later, the New England Supervisory Special Agent 1 had learned that his former CHS had developed the information related to Trump while working with Glenn Simpson and Fusion GPS. Thus, it appeared that in July 2016, the FBI had not yet determined that the dual reporting it was receiving actually was coming from the same source, that is, Simpson and Fusion GPS. Further, it does not appear that the FBI was aware of the fact that essentially the same information the former CHS was providing to New England Supervisory Special Agent 1 was being provided to the media by Simpson and Fusion GPS. This was a pattern similar to that later employed in the Alpha Bank matter, when the Alpha Bank allegations were provided to members of the media by Fusion GPS and then to the FBI through Michael Sussman. 4. Other investigative activity prior to the receipt of Steele reports. Between the time the FBI opened Crossfire Hurricane investigation and when Crossfire Hurricane investigators first received the Steele reports in mid-September 2016, the FBI took the following investigative steps. As discussed above, Stroke and Supervisory Special Agent 1 met the Australian officials to verify the information provided by Papadopoulos. Records and open source data were checked on the 4 Crossfire Hurricane subjects. Travel of subjects was monitored. Some records were obtained from other federal agencies and a foreign government. FBI CHSs and USCs were used to engage with some of the subjects. The OIG review provides the following succinct summary of the FBI's investigative activity prior to the receipt of the Steele reports. By the date the Crossfire Hurricane team received the 6 Steele reports on September 19, the investigation had been underway for approximately 6 weeks, and the team had opened investigations on 4 individuals: Carter Page, George Papadopoulos, Paul Manafort, and Michael Flynn. In addition, during the prior 6 weeks, the team had used CHSs to conduct operations against Page, Papadopoulos, and a high-level Trump campaign official. Although those operations had not resulted in the collection of any inculpatory information, FBI personnel told the OIG that the FBI did not use national security letters or compulsory process prior to obtaining the first FISA orders. The FBI Deputy General Counsel Anderson said that early on, FBI managers took off the table any idea of legal process because the FBI was trying to move very quietly. Similarly, that quote is from FBI Deputy Counsel General Tricia Anderson, describing statements by Comey and Deputy Director McCabe on the importance of keeping the investigation covert. That was a footnote. Page 67. Similarly, members of the Crossfire Hurricane team told the OIG that they avoided the use of compulsory legal process to obtain information at the time in order to prevent any public disclosure of the investigation's existence and to avoid any potential impact of the election. Notably absent from the list of investigative steps taken were the following non-public, non-compulsory options. Interviewing Page, particularly once the FBI's interest in him was publicly disclosed by the media. In fact, 2 days after the disclosure, Page wrote to Director Comey offering to be interviewed, but the FBI elected not to do so. Asking Page, who volunteered to be interviewed and had spoken with the FBI when asked to do so on prior occasions, if he would consent to a polygraph exam or provide access to relevant electronic records. Using other standard investigative techniques not requiring a court order, interviewing Papadopoulos, the actual source of the Paragraph 5 information. Another step that the Crossfire Hurricane investigators could have taken, but chose not to, was the use of PIN registers and trap and trace devices. Although FISA authorizes the government to obtain a PIN register when the information is likely to be attained, is relevant to an ongoing investigation to protect against clandestine intelligence activities. Case Agent 1 told the OIG that he saw PIN registers as a criminal authority. FBI OGC Unit Chief 1 could not understand why investigators were working on Crossfire Hurricane were not seeking authority to use PIN registers and trap and trace devices, page 68. In terms of the analytical capabilities that were applied to Crossfire Hurricane, Lisa Page testified that the FBI used line-level analysts who were super experts on Russia. The FBI Inspection Division report found, however, that the intelligence analysts selected for Crossfire Hurricane were uniformly inexperienced, and that none of them were subject matter expert analysts. Aside from Auten, it's A-U-T-E-N, the most experienced analyst had less than 9 months of experience working in that capacity, 2 had less than 4 months experience, and 2 came straight from analyst training. The analysis done on Crossfire Hurricane was also limited to the Counterintelligence Division's failure to integrate the Directorate of Intelligence into the investigation as required by policy. Rather, in at least one instance, Assistant Director of the Counterintelligence Division, Bill Priestap, appears to have deliberately shut down the involvement of the Directorate of Intelligence in an enhanced validation review of Christopher Steele, a key source. B. The FBI and the department's disparate treatment of candidates Clinton and Trump. In the course of the office's investigation, we learn of allegations involving possible attempted foreign election influence activities associated with entities related to Clinton, in addition to the allegations related to Trump. The office sought to determine, to the extent possible, if the actions taken by the FBI and, in certain instances, the department, to address the allegations were consistent with those taken by the FBI relating to the allegations of Russian foreign election influence attached to the Trump campaign in July 2016. Comparing the respective investigative activity was significant to the investigation since it could support or undercut allegations of institutional bias against either candidate. As an initial matter, given the, page 69, particular nature of the allegations related to each campaign, attempting to view the FBI's investigative activity in an apples-to-apples approach is undoubtedly an imperfect method to analyze whether the FBI engaged in disparate treatment of the campaigns. Nevertheless, the comparisons are instructive, and below we discuss our observations regarding the investigative approach to allegations of foreign election influence against each campaign. Number 1. The threat of foreign election influence by a foreign government. 2. Beginning in late 2014, before Clinton formally declared her presidential candidacy, the FBI learned from a well-placed CHS, which is CHS-A, that a foreign government 2, was planning to send an individual, non-U.S. person 1, to contribute to Clinton's anticipated presidential campaign as a way to gain influence with Clinton should she win the presidency. The FBI's independent corroboration of this information is discussed in the classified appendix. Upon receipt of this information and the predication it provided, Field Office 1 sought to have 1 or 2 other better positioned and higher resourced field offices open a counterintelligence or public corruption investigation into these allegations, but Counterintelligence Division Executive Manager directed Field Office 1 to open a full counterintelligence investigation into the matter. Field Office 1 sought FISA coverage of non-U.S. person 1 almost immediately in order to obtain access to his or her email and to conduct a search of him or her as soon as he or she arrived in the United States. Although Field Office 1 attempted to obtain expedited approval for the FISA authorization, the certified copy of the application was sent by OI to the FBI headquarters for final approval, where it remained, according to Field Office 1, SAC-1, in limbo for approximately 4 months. According to another agent, the application lingered because everyone was more careful, that was in quotes, and scared with the big name Clinton involved. They were pretty tippy-toey around HRC because there was a chance she would be the next president. Similarly, the Field Office 1 SAC-1 told investigators that when, page 70, she spoke with the Counterintelligence Division Assistant Director and Deputy Assistant Director, they alluded to the fact that they did not want a presidential candidate on tape, even through Field Office 1 SAC-1 believed that was a very remote possibility. According to the records the office reviewed, it appeared that the delay also may have been partially attributable to a decision to await the confirmation of the incoming Attorney General. The FISA was ultimately conditioned on the requirement that the FBI give defensive briefings to the various public officials and candidates of both political parties, including Clinton, targeted by Foreign Government Number 2. On December 16, 2014, FBI OGC Section Chief Rick McNally summarized his conversation with Stuart Evans, the Deputy Director Attorney General responsible for OI, about the proposed activities. I spoke to Stu Evans. He suggested that we go back to him rather than calling the AAG. But the question was not about PC, no legal issue. It was about what was the FBI's thinking about this case, specifically whether or not we think that the politician's staff and the politician are complicit with the target, meaning that the poll and the staff know that the target is working for a foreign government and has some bad intent. Or alternatively, do we think that the poll and the staff are unwitting? And if they're unwitting, are we considering some sort of defensive brief to the politician or staff to mitigate risk? Certain critical activity in the investigation was delayed for months due to, among other things, concerns that a politician, Clinton, was involved, and that the investigation might interfere with a presumed future presidential campaign. In line with the directive, the FBI ultimately provided defensive briefings to the officials or the representatives, though it took, page 71, approximately 11 months from the receipt of the original allegations. Clinton elected to receive the defense's briefings through her personal attorneys. The use of defensive briefings in 2015 contrasts with the FBI's failure to provide a defensive briefing to the Trump campaign approximately 1 year later when Australia shared the information from Papadopoulos. Significant to the question of whether a defensive briefing was appropriate here, it is, as it was determined to be just months earlier when a defensive briefing was given to Clinton via her lawyers, is the fact that Australia had specifically noted it was unclear whether Papadopoulos or the Russians were referring to material acquired publicly or through other means. Further, the office's investigation revealed that the FBI engaged in what were likely very limited discussions as to whether any such briefing was appropriate. Deputy Director McCabe informed the OIG that he did not remember participating in any discussions about providing a defensive briefing as an alternative to opening a full counterintelligence investigation. McCabe noted that at the time Crossfire Hurricane was open, the FBI had to do some work to have a better understanding of what it had before taking a step as overt as providing a defensive briefing, because the briefing could eliminate or reduce your ability to get to the bottom of the threat. On the other hand, Assistant Director for Counterintelligence Priestat said that he discussed the issue of defensive briefings with others. He explained that the FBI provides defensive briefings when we obtain information indicating a foreign adversary is trying or will try to influence a specific U.S. person, and when there is no indication that the specific U.S. person could be working with the adversary. Page 72. We had no indication as to which person in the Trump campaign allegedly received the offer from the Russians. Because the ability existed that someone on the Trump campaign could have taken the Russians up on their offer, I thought it was wise to open an investigation to look into the situation. How these observations can be reconciled with the defensive briefings previously provided to Clinton and others is unclear. The FBI's decision to conduct defensive briefings in the investigation of Foreign Government 2's foreign influence efforts is curious, even that the defensive briefing could reduce the likelihood of success of any investigation into the foreign influence allegations, and that candidates and public officials might then be less likely to interact with representatives of Foreign Government 2. The decision to provide defense briefings to Clinton and others seemed to conflict directly with McCabe's notion that providing a defensive briefing to the Trump campaign could eliminate or reduce your ability to get to the bottom of the threat. Similarly, with respect to the Trump campaign, Priestat's twofold concern that the FBI was unaware of which member of the Trump campaign allegedly received there's a footnote on the previous page where all the prominent people in the investigation, the heads of these agencies, said they don't remember any kind of discussion about whether they're going to brief the Trump campaign. And then there's a footnote here on this page. It reads, OIG interview with EW Bill Priestat on August 22, 2018. Some references. Similarly, General Counsel Baker advised that there was some limited discussion about providing a defensive briefing to the Trump campaign regarding the Papadopoulos information. However, in his words, there was also the thought that why hasn't anyone from the Trump campaign reported this information to the FBI? Baker advised the FBI felt it did not know to whom in the Trump campaign it could provide a defensive briefing, as there was uncertainty about who could be trusted with the information. Additionally, there was some concern about tipping off the Russians as they became aware the FBI had learned of its scheme through a briefing provided to the Trump campaign. Baker advised that the FBI did not wish to mess up the political process by going over with its investigation. He also advised the FBI needed to do more work, figure things out, and come up with a strategic plan before deciding how to proceed. He said part of that plan may have included providing a defensive briefing to the campaign. OSC interview report of James Baker on February 7, 2020. On June 19, 2019, at 3, Case Agent 1 recalled a notional idea of going directly to the Trump campaign leadership with a briefing about the intelligence threats. It says C, OSC report of interview of Headquarters Supervisory Special Agent 4 on May 28, 2020. It was important to know if the Clinton people being targeted for foreign influence knew of his targeting. Headquarters Supervisory Special Agent 4 did not think they had any information one way or the other on that issue. Field Office 1, handling Agent 1, is quoted as saying, was okay with the defensive briefings because he felt the common goal was to neutralize Foreign Government 2's intent to interfere with the elections. Page 73. Similarly, with respect to the Trump campaign, pre-steps twofold concern that the FBI was unaware of which members of the Trump campaign allegedly received the offer from the Russian government, and the possibility existed that the campaign had ultimately taken Russia up on the purported offer is also unpersuasive when viewed in light of the planned activity of Foreign Government 2, given the unknowns that existed in that investigation. Nevertheless, the FBI went forward with the offensive briefings in that investigation, an investigation predicated on the receipt of corroborated information, but failed to conduct defensive briefings to the Trump campaign, an investigation predicated on less certain information. The FBI's and the department's measured approach to these foreign influence allegations involving Clinton also stands in stark contrast to the speed of which the FBI undertook to include the Steele report allegations in the FISA requests it submitted to OI targeting page. Indeed, as discussed below in Section 4D1B3, the Crossfire Hurricane investigators received the initial Steele report on September 19, 2016, and within 2 days had included portions of those allegations in the draft page FISA submitted. As noted below, approximately 1 month later, on October 21, 2016, the FISC signed the initial authorization. During the period between the drafting of the initial FISA request and the approval of the application by the Deputy Attorney General Evans, who was previously consulted regarding the allegations of Foreign Government 2, to his foreign influence effort directed at Clinton and others, raised concerns in a call with FBI Special Agent Lisa Page about, among other things, Steele's personal bias, unknown sourcing, and that the use of FISA's authorities was bad from a policy perspective, to which Page's notes appeared to indicate in response, "We accept info from biased people all the time. Would look terrible if we pull our punch due to political concern. We believe the info and sourcing is good. As leaks continue to trickle, is one of the only opportunities to see reflections."